Thank you for joining us for the 8th episode of our Association Matters. We appreciate you taking your time to attend our seminars. I'm Marita Butzbach, the Executive Vice President of Property Management Operations for Lang Management Company. With me from Lang Management today is Lisa Littman, who is our Regional Vice President of Property Management Operations. And we also have two of the team members from Kaye Bender and Rembaum, Jeff Rembaum and Alan Schwartzseid, who are here today.
Hello.
I'm sorry?
Hello.
Oh, hello. They're here today that we are going to go in depth about mediation processes and how it affects your associations. And again, we appreciate you all coming today with that. Jeff, we've been working with Kaye Bender and Rembaum for a very long time. They manage several of our associations and have given us very good advice in the past. And some of our newer associations actually have brought them on board after developer control, and we have really enjoyed a nice working relationship. So thank you for doing this for our clients and others today. We truly appreciate
Oh,
it.
our
Happy
pleasure.
to help.
It's a pleasure working with your team too.
Thank you.
Thank you.
So at this point, kind of to start everything off, we're going to go through the basics so that you all understand exactly what is mediation, how does it work, and then some of the other details that tie into it. And with that, Jeff and Alan, I'll turn it over to you to start their introduction to mediation.
Sure thing. I thought you were telling to tell us all about mediation this morning.
We can tell you
So,
stories.
No,
you know,
that's the other side where managers can't practice law. So there you go.
yeah, but you
A
can
mediator doesn't have
participate,
to be a lawyer.
Yeah,
right?
yeah.
You can participate in mediation. You can even be, right? They can be a certified mediator if
Yep.
they take the course. You just need to take a week, sit your 40 hours, do a whole bunch of practice mediation, sit as an observer, and poof, you too can be a Florida Supreme Court certified circuit civil mediator and be like Alan and woo, have two credentials and be a county court mediator too. One of these days I'll get around to taking that second course, but we'll see. So, when mediation first came out as a opportunity for homeowner associations, I was one of the naysayers in my mind anyway. I thought, oh, this is just going to be a waste of time. It's not going to work. Da, 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 da. Sure enough, 90%, 85, 90% of all of the Emily, well, hello. What a nice surprise to see one of our other attorneys on this live webinar. Emily, you joining us for a particular reason? Nope, she's gone.
Nope,
That,
she's gone.
that was one of the best. So anyway, mediation, didn't think it was going to work. Turns out, much to my surprise, 85, maybe 90% of the disputes when you have reasonable parties seem to get resolved. What is the magic? What is the mystery? The magic is knowing how the process begins, what occurs at the mediation table, and what happens if mediation doesn't work. Alan is going to talk to us in a few minutes about what happens at the mediation table from the mediator's perspective. I'm going to start out and just give a brief introduction and talk about the process. We're not going to talk about yet what's right for mediation as much as what the process is once we want to use it. And then we'll circle back around to the appropriate disputes for mediation. But short story is the aggrieved party. And let's say it's the association who's upset because this particular owner just won't clean their driveway. They won't clean their roof. You've tried fining. You want to go into court. Okay, can't just go to court in the homeowner association context. We have to do pre-suit mediation first. How do we get there? We have to send a letter. About 80% of it is derived from the statute itself, and then 25% of it is fill in for the attorney or the aggrieved party to put the other side on notice of the dispute. They have 20 days from the date they receive this letter. Now, in this letter, it has to identify the dispute. It has to include the name of 5 mediators that are competent and capable of mediating the dispute. It has to be sent U.S. mail. It has to be sent certified, return receipt requested. The other side gets it. They read it. They throw it in the trash. Whoops. That's going to cost them later. We'll talk about why. Let's say they read it and they respond. They circle one of the 5 mediators, whichever of the 5. If they were to write back, no, we don't want to use these 5. We want this one. That's non-compliant. They fell into the trap. Don't fall into that trap. So you get 5 mediator names, you circle one. You sign your name on the bottom of the paper as the aggrieved party. You have to send it back to the association. How do you send it back? You send it back U.S. mail, certified return receipt requested. So the receiver of the association's letter picks a mediator and signs it and sends it back. U.S. mail, certified return receipt requested. If you miss those steps as the recipient of the letter, and the association then, because you didn't respond within the 20 days, decides to litigate the matter. Now, hypothetically speaking, if you, the homeowner, were to win that litigation because you chose not to participate with the pre-suit mediation process, you are deprived of receiving your prevailing attorney's fees and costs. You're wiped out. You collect nothing. So you're giving the association a wide open opportunity to go to litigation risk-free because they don't have to worry about losing because you're not going to get your prevailing party attorney's fees and costs. So that's the penalty for non-compliance with the 720 pre-suit mediation process. Now, interesting, a few years after this came out, the Condo Act then said, well, instead of mandatory non-binding arbitration, you can go to pre-suit mediation. And if you're not happy with the result there, then you can go to circuit civil. Now, if you ask folks like Alan and me, where would we rather be? We'd rather be in a courtroom than with the division of arbitration. There, they call it mandatory non-binding. It's sort of an oxymoronic term. It's mandatory. Well, okay, you got to do it. It's non-binding because if you're unhappy with the arbitrator's decision, it doesn't go, shall we say, hard. It doesn't become locked for 30 days. So if you're upset with the arbitration decision, you can then appeal it into the circuit court. You're not dealing with judges in arbitration. You're not dealing with the most, I'm going to say the most learned group of association practitioners. I'm not exactly sure where they're coming from sometimes. They don't have to follow stare decisis. They don't have to follow concepts of the law. They don't even have to follow their own rulings in subsequent cases. It makes no sense. It ought to go away. As you can tell, I am not a fan of the condominium arbitration section or the process for that matter. I think they do a great job with regulatory, but when it comes to arbitration, we've all had horror stories. We could take a day, bring all of our litigators in, and just tell you one horror story after another of where the arbitration section just went totally out of nowhere. We can't figure out where their reasoning is coming from. But anyway, that's another lecture for another day. So that's our pre-suit mediation process. We have a problem with an owner. Association hopefully will identify 5 good association mediators, right? There are mediators who know this body of law. You want to pick 5 of them to go in the association's letter. Then the association sends the letter. The aggrieved party, or not the aggrieved party, we're the aggrieved party. So the recipient gets the letter, the homeowner, and then they have to remember, select one of the 5, sign it, send it back, U.S. mail and return receipt requested. If ever there's a mistake I see, they don't send it back, both U.S. mail and return receipt requested, which gives you a statutory argument that they were non-compliant. Whether the judge will buy it or not, don't know, but it's our job to make that argument. So that's like a real brief overview of the statutory process. Now, what kind of disputes are ripe to go into mediation? Not everything can go to this pre-suit mediation. For example, collection foreclosure. Forget about it. We're not going to use the pre-suit mediation process. What we're going to use it for is use or changes to a parcel, to your lot, or to the common areas. Challenges to amendments to the association documents, meetings of the board and committees appointed by the board, membership meetings, but not election. The division of condominium arbitration section, believe it or not, has the initial sole jurisdiction on election disputes for condos and HOAs. The other pre-suit mediation for an HOA is access to the official records and, of course, covenant enforcement. And remember, for a great number of the disputes in a condominium, you can also use that pre-suit mediation to require an owner to take action or to get them to refrain from taking action, dealing with material alterations to common elements, things such as that. Alan, I'll tee it up for you.
All
talk
right.
a little bit about the actual, okay, we sent the letter, everybody complied. What I didn't really go into detail with is the timing. So you basically have 90 days to set the mediation from the date of the letter. So now the parties have participated. Everybody has paid one half of the mediator's minimum fee. It is the day of the mediation. And everyone logs on because we typically do mediation electronically these days. And Alan, you're meeting us for the first time.
Well, it's
Here we
great to
go.
be
Alan's
here.
going to kind of take us through that process.
All right. Well, let me take one step back for just a second because I did have a couple thoughts I just wanted to add on what you shared.
Please.
One thing that I've seen and personally done when I was litigating these community association covenant enforcement cases in particular is you'll have an owner who tries to comply, and as Jeff mentioned, they just screw it up. And the way that I customarily handle those is if the board still wants to get this settled before having to file the lawsuit, most of the time, as Jeff mentioned, if you've got reasonable people on both sides, you're going to get these things settled at mediation. So my thought has historically been, okay, well, we will agree to mediate, but we're not waiving the deficiencies in the way that you submitted your response. We don't explain what those deficiencies are, but we basically write back saying, okay, thank you for your response. We don't find it statutorily compliant, but we do want to get this resolved. Let's sit down, see if we can resolve it. And as Jeff mentioned, I'll go into what that process entails in a minute. But this way, the parties still get to sit down before we spend thousands of dollars, before there's a potential fee entitlement on both sides. Although, as Jeff mentioned, the owner already screwed this up, so they probably won't have that fee entitlement. It just gives the parties an opportunity to get things settled for less money, is the way that I put it. Now, the other
I like
thing that
that
we
idea.
didn't
Good
mention
approach.
is these don't only go in the direction of association to owner, they can also go in the direction of owner to association. So the second you get one of these offers for pre-suit mediation as an association, I don't care if it's valid or not. My perspective is, okay, let's agree to go to mediation. And when they file their lawsuit, I'll explain in a minute how this process starts. But in mediation, our response is we think this is complete garbage. We don't think you have a claim. We don't think it's subject to pre-suit mediation, but we're here in good faith to try and get this thing resolved. So, just wanted to share those thoughts, and obviously, with respect to the DBPR's arbitration program, I agree. The biggest problem I have is that they don't follow precedent, and that precedent includes not even following their own opinions from a week before with the same arbitrator and the same parties. So, I just mediation
Yep.
is the way to go, in my opinion. You are, and we'll get into this in a minute, but you get to control your own fate in mediation. You don't get that in arbitration. There's someone making a decision for you. And I think that is the biggest piece of why I always recommend when you've got a condo that can go to arbitration or go to mediation every time. Regardless of all the other stuff Jeff mentioned, which I agree with, I think that's one of the most important pieces is just getting to decide your own destiny. All right, so
Alan, before you
Jeff,
jump into the mediation itself, because this came up as some of the questions too, who can
okay.
actually represent at mediation? What is their authority to settle at
We're
the
going to jump into all that. That's part of what Alan
Yeah.
is going to be looping back
got
into.
Yeah, that's definitely part of what I'm going to get into. So let's just jump into it and we can move this forward. What is mediation is really the biggest question that everyone asks when they get one of these offers for pre-suit mediation. And Jeff will get into later. That's not the only time we're going to deal with mediation, but it's basically a meeting where the goal is just to settle a dispute with someone else helping out that is a neutral third party. So Jeff and I are both also mediators with experience as mediators. I mean, I've done probably somewhere between 75 and 100 mediators as counsel for one of the parties, but also 40 or 50 as the mediator. And my goal when I'm the mediator is not to be the attorney. I'm not allowed as a mediator, in fact, to give anyone in the room legal advice. So I can't even say, well, but doesn't this case say X? I can't even say that. I can ask, well, have you considered what the impact of that case might be or this statute might be? But I'm not allowed to say, I think you're wrong. I can say, what is your likelihood of success? I think if you end up in front of a judge, the judge might consider X. But this mediator is just someone who is a neutral third party that gets in the room and tries to get a dispute resolved. They don't have any decision-making ability. They're not an arbitrator. They're not a judge, although they could be a former judge. They might do arbitration separately, but that's not the role they're in today. They're not even an attorney in their capacity that they're sitting today. As I mentioned earlier, you don't have to be an attorney to be a qualified or certified mediator. So literally, the mediator's entire role is to help the parties reach a mutually acceptable settlement. Now, that term mutually acceptable is one of the most important parts of mediation. If the parties don't like what the other side is proposing, no one's going to tell them they have to accept it. The mediator is going to push them towards finding that mutually acceptable resolution, but the parties get to decide their own fate. If you don't like what the other side's proposing, you either come up with a counter proposal or you say, all right, we're done, and you move on. Again, there's no judge, arbitrator, decider of fate. The parties get to determine their own fate. Now, mediators are subject to separate rules. It's not the rules governing the bar. It's not the rules governing CAMs. It's not the rules governing board members. It's literally an entirely separate set of rules that are put out by the Mediator Ethics Advisory Committee through some opinions. And there are also some rules for certified mediators. But it's a completely separate concept from someone's deciding for you. Another really important concept in mediation is confidentiality. There's an entire set of law that dictates what is confidential in mediation, and it's almost everything. So really the only exceptions are elder and child abuse, criminal acts that are going on, and things like that. Everything else, you can say pretty much whatever you want in mediation. The other side can't bring it up in court. Now, that doesn't mean they won't do discovery after the fact if you end up in litigation to try and get those same facts from you. But it's an opportunity to express, a lot of times, like in a personal injury mediation, that's the first opportunity that the defendant side gets to say, I'm sorry this is happening, because otherwise it's taken as an admission. But this is confidential. So you're allowed to walk into mediation and say, I'm sorry that you lost your spouse and that's the reason that this is going on. I really feel for you. And we're trying to give you as much time as possible, but you got to resolve it at some point. You can walk into mediation and say that without risking selective enforcement and things of that nature that you would otherwise risk if you put a statement like that in writing.
So nothing you say in mediation can be used against you later?
Correct. Now, again, that does not mean that the parties can't elicit the same testimony in court. So you're still giving some information away that can be used later, but it can't be admitted as they made this statement during mediation. There are actually severe penalties for disclosing anything that was discussed in mediation.
Alan, if we have a 5-person board, and I know we're going to talk about, what the authority that the board needs to come to at the mediation table, which we'll get into. But since we're talking confidentiality, we have a 5-member board. 3 members appeared at the mediation. The other 2 want to know what happened. Because they are also fellow board members, does the privilege extend to them?
It does, and it's specifically because it's the same as the attorney-client privilege would extend to them. So you want to discuss it with your manager, your directors, your officers, or your attorney. Those are all acceptable people to share that information with. The
But they have to be
discussion
admonished
itself
not
can
to
be
share?
shared.
Yeah.
Now, when it comes to the end result, that might be a different story. You can share that with pretty much anyone. Either we settled or we didn't. That's not confidential. But what I would strongly suggest is that if you're debating whether to share information that you received as part of this mediation process in general, not just during the actual conference, but even in a pre-suit, a pre-mediation statement by one of the parties, which we'll get into the procedure in a minute. But any information that you get, I would run it by your attorney as to whether or not you'd be subject to these sanctions that I was talking about earlier if you disclose that information outside of the people that, as Jeff mentioned, are subject to that same confidentiality. So again, just to reiterate, the board, the management firm, meaning anyone within that management firm, and your attorneys. Those are all the groups that you are allowed to share all this information with. Sharing it outside of those groups, I strongly suggest that you get legal advice before you risk breaching that mediation confidentiality.
And Alan,
So,
one of the things I just want to cover, because we probably have a lot of board members who are on this seminar today, that means not sharing that information with your spouse, who
correct.
shares it with the social committee, who shares it with other, the landscape committee and what took place in that mediation
Right.
and out to the community. So yeah, unfortunately,
Correct.
members have a bad habit of running things through their spouses and it gets out into the neighborhood.
Yeah. And one thing I want to point out, because I did mention attorney-client privilege, that is held by the board. Okay, that's attorney-client, which is a separate privilege. The confidentiality regarding mediation is held by all parties to the mediation. So you don't get to decide as a board, we're going to disclose this information to people outside of the board. It has to be with the other side's consent, presuming you have only one other party. If you've got five parties, now you got to get the consent of all of them. So understand this is confidential unless everyone agrees that it's not. So let's jump into the process since we've kind of gone through the general specifics, so to speak. Now, mediation starts with setting. Obviously, you're going to have a notice of mediation. It's going to say where, when, and how that mediation will be held. As Jeff mentioned, I think I've done 2 in-person mediations in the last, basically since COVID started. These are almost all held online, which is why we're able to do them statewide without an issue. I can attend a mediation in South Florida just as easily as I can attend one that's in my office. So the reality is the location of the mediator has become less important, just like the location of your attorney is in a lot of respects become less important. You get the notice of mediation. It's going to probably include that Zoom link. Do not share that with anyone outside of the mediation parties, because that's when you're going to have people coming in that aren't subject to that confidentiality if you start sharing that information. Okay, you want it to be limited to the people that are an authorized attendee at the mediation. Now we show up at mediation. The people that are actually there should be limited to the parties, the management firm, and counsel. When you've got the owner who says, "Oh, I'm helping out my son, he doesn't understand legal issues," the board has the ability to say that person's not invited into the mediation if they're not an owner of that property and not subject to whatever claims that the association has brought. Now, I'm not suggesting you should always do that. If you want to be kind, that's a great way to start a mediation by saying, listen, we could very easily say we're not going to allow this person in. If they cause any problems for the mediation process, we're going to have to ask them to leave. But as long as they agree to be subject to the same confidentiality, they can attend. You might have an interpreter for someone who doesn't speak English, but other than that, the people that are attending are really the parties. And we'll get into in just a second. The board should designate 1 or 2 people that are attending with full settlement authority instead of the entire board having to show up unless that's what the board wants. You're going to have the mediator. You're going to have the attorney for the association. And if the owner has an attorney, that person will be there as well. Now, we're going to start that mediation by confirming, is everyone in the room actually authorized to be here? At least if the mediator's doing it right. The mediator will figure out who's on which side, who they pertain to, whether they're authorized to be there, and then we actually get started. The mediator starts with a brief introduction regarding a lot of the things that we just mentioned, the mediation process, how it's going to work. We get into, okay, we're going to have breakout rooms, etc., which we'll get into in a minute. The mediator goes through the whole process. Once the mediator's done, he or she will open up the floor to the first introductory statement. That introductory statement is basically, here's our side of the story. So usually the party that raised the claim, usually that's the association, is going to go first. Then the owner or the respondent, whoever that may be, is going to get to go next and basically say, I'm going to skip the line from Joe Pesci's famous line, everything that guy just said is BS. But, they get to say whatever they want. Now, the thing that I always recommend when I'm a mediator is don't interrupt. You don't have to agree with everything that the other side is saying. If we agreed on everything, we wouldn't be at mediation. We would have settled already. So just let them speak, even if you disagree, and then tell everyone why they're completely wrong when they're done speaking. So usually it'll go intro by one party, intro by another. If you've got a lot of parties, they may all get their own introductory statements, especially like in a construction defect situation. But usually you only have an owner and an association. So each side gives their little introduction, depending whether it's gotten a little bit of, animosity going on. or if it's really just a discussion that's going on, the mediator is going to decide whether to spread everyone out into breakout rooms, which is how Zoom calls them. They used to be called caucuses, which is everyone goes to their separate place so they have their individual confidentiality. And then as part of that introduction, the mediator should be asking the parties, are you okay with me sharing anything that you say with the other side that's said during those caucuses, those breakout sessions, unless you tell me to keep it back? And the mediator should get an acknowledgement from everyone in the room that that's okay. If the answer is no, the mediator has to ask on every single fact and every piece of law they receive, are you okay with me taking this back to the other side?
Or just tell me what you're not okay with me telling the other side
Right.
from this
So I like
mediator's
to get
perspective.
that consent right up front. I'm allowed to tell the other side anything that I think will help us get to a settlement unless you say don't. So again, we might break out into separate rooms. The mediator is going to bounce back and forth, and that's when the process really starts. After the introductions are done and the parties break out and we're talking back and forth regarding settlement terms, hopefully the mediator is not just a monkey taking these, they said this, what do you say? Hopefully the mediator is adding to it, and that's why I've focused the beginning of my practice on only HOA and condo disputes because it's what I know. So people like Jeff and I have that creative solution that we've used 30 different times that the parties might not otherwise think of. That's where a good mediator comes into play. It's not ferrying offers back and forth. It's in coming up with creative solutions. And that we're allowed to do. So again, we go back and forth for a little while. Hopefully we settle quickly. My goal is always to have a signed settlement agreement before we actually close out the mediation conference. Hopefully we settle. If we don't settle and the parties say, no, 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 none of this is going to work for me. We're moving on with our lives. We're done with this. Okay, that's called an impasse. The parties close out, and as Jeff mentioned, whoever raised the claim is allowed to file their lawsuit whenever they feel like it, presuming no statute of limitations or anything like that comes into play. Now, one thing that I tend to do that I know a lot of mediators don't like is say, listen, it sounds like we've gotten you guys a lot closer than you were when you first walked into mediation. I'd like to keep the mediation open, even though we're closing out today's conference, so that the parties can email back and forth. We're not going to settle today, but I think we'll be able to settle if we keep this going via email for another week or two. And if we have to come back for another session to finalize everything, fine, we will. But keeping it open instead of reaching that impasse immediately gives the parties the opportunity to say, yeah, we're not quite there yet. We still got to talk about a couple things. We got to go do some research without having to reach the impasse and start from scratch. So that is just a creative solution that I've come up with. I know a lot of mediators want to just be done with the situation the day of the conference. We either settled or we didn't. I'd rather have that, 90+% success rate that Jeff mentioned, which as a mediator I have seen, but a lot of those successes came from keeping the conference open for another week, keeping the confidentiality in place, which is the most important part, and keeping it going for another week or two. So presuming that the parties are able to agree on terms, and we won't go through all of the terms that might go through, into that settlement agreement, but, if they're able to agree on everything, you have that signed agreement, the mediator reports that there was a settlement, and then the parties just need to do what the settlement agreement says that they'll do. So that's really the process from start to finish. The mediator is going to send out a report after all of this is said and done, saying what the result was. They are not going to put any confidential information into that report. The other thing to keep in mind, because a lot of people want to bring the mediator into these, oh, well, I think a settlement was reached and the other party doesn't. I don't know about Jeff, but in my mediation engagement agreement, there is a separate rate if you force me to come in and testify because I'm obligated to tell the judge I'm not allowed to testify about anything that was discussed during this mediation other than for purposes of determining whether a settlement happened.
Hey, Alan, which
So,
firm are you with?
me?
Yeah. What's the name of the firm?
Kaye Bender Rembaum.
I'd like to think we're using the same mediation agreement for our potential
I'm
mediations.
99% certain, but you never know what. Listen, I also know my partner, and I know you never know what changes are going to happen. I'm sure I'll find out about it at some point, but I don't like to presume anything.
That's
So
so funny.
anyway,
Funny, funny.
but But that's the process in a nutshell. I mean, there's a lot more that goes into it. Some of these mediations can take days. Some
Mhm.
of them are done in 2 hours.
Well,
Uh,
hold on. That's where I wanted to stop right there, right? Because some of them are done in 2 hours, some take days. I don't know about you, but it is rare that I'm in a mediation, either as a mediator or representing a party, that it's for, I mean, it just, the time goes by. Used to frustrate me. It's minimally 4 hours, plan on a half a day. And it seems as though the longer the mediation goes on, the higher the chance of settlement actually increases, strange as it is. I
yep.
can't tell you how many mediations start at 10 in the morning and it's now 5:30, 6 o'clock, 7 o'clock at night. I had one go to 2 o'clock in the morning once. Can you believe that?
Wow.
Oh, yeah,
Sadly,
as
I
a younger
can.
attorney. We got through it though, but nobody, that was long before Zoom was an opportunity. So we're all down in South Miami in a big, office building. It was crazy, but we got it done. It's just, what about full settlement authority? It seems like a lot of association boards miss the understanding that if they're going to mediation, they can't say, well, let me think about it. Let me get back to you. I'm going to get back to my board. No, it's one thing to have the board on standby because everybody is waiting and they're going to make a decision, but you need to go into that room with some type of settlement authority. And if you exceed that authority, because you still want to make the deal, but it goes beyond the grant of power, then you should have a backup method of being able to be in touch with your board members so that you can get a quick consensus to get this dispute resolved.
Yeah,
And
and I think it's
we've
very
actually,
important to keep in
we've had
mind.
We've had
Oh,
board members call from the meeting
Mhm.
to other board members to try to get something resolved where they know if it's a five-person board, they've given the authority to three of them that if the president's there, he can call two of the others to make sure they're in agreement on the settlement
no,
because
no, they need to go into that room with some type of settlement authority.
Right.
But if
It's
the potential offer now or the settlement terms exceed that grant of power,
Mhm.
then it's nice to have the board there. But the one
yep.
thing you don't want a mediator to hear in mediation is, I don't know. I don't have any authority to make decisions today. You are now in violation of the mediation statute, and you're giving your opponent a tool to use against you.
And
so
I don't
just to be
how
clear,
that would resolve itself, in the courtroom situation, trying to resolve that you be arguing that they came to the mediation in bad faith.
so
well, and it's
if
not
one of the
even
board
just bad
members,
faith. I've seen it where the judge finds that because you didn't come with full settlement authority, you didn't attend mediation and you've not met your burden. And that fee shifting that we talked about earlier, where
There
one
you go.
party gets their attorney's fees, not anymore. So
so
I do think that it's important based on what Jeff is mentioning, and I fully agree with everything he said. Have a meeting in advance of the mediation conference, a closed meeting of the board with counsel to figure out what is the association actually willing to give up here? What do we need to get out of this mediation? What are we willing to settle for? Because, like Jeff mentioned, without that full settlement authority, which isn't just oh yeah, the board told me that I can do XYZ. Full settlement authority can be you're authorized to tell this guy to go fly a kite. It doesn't have to be any specific remedy that's going to be acceptable, but you do have to know exactly what you're authorized to do and what you're not.
So, Alan, in this instance, what happened is the amount that they were looking to settle was higher than what the board president walked in with the authority from the board. So he literally called two other board
Yeah.
members while he was in the meeting to say, look, this is the amount they're looking for. I'm supporting it. Here's why. I want to make sure we have a quorum of the board that has agreed to this. Did they do
And
something wrong in that instance?
no, let me be clear. The fact that you've clarified that they walked in with authority to settle for a certain amount means they did their job. The
Now, what
fact that
about
they had authority to say the president is authorized to settle for X dollars means that they walked in with full settlement authority. There's nothing wrong with getting more than the authority you initially walked in with. It's if you didn't have authority to agree to anything and the board hadn't sat down and had the discussion of making the conscious decision, we're not going to pay a dime, that would be problematic.
I want to bring in real quick the need for an attorney-client privilege board meeting, because how is the board going to discuss the settlement parameters before the mediation and, if you will, grant power to those individuals attending the mediation? You're going to do that in an open board meeting and really waive all that confidentiality? I don't think so.
No.
So
No.
you need to plan on an attorney-client privilege board meeting before the mediation to go through all of these issues. So it should, for those of you that are in the pre-suit mediation process, just remember sometime before that mediation, you're going to want that attorney-client privilege board meeting to handle and discuss those issues. Now, let's say they call the board member, and now we have an upset community member. Wait a minute. You guys made a decision outside a properly noticed board meeting. You had a board meeting, it was attorney-client privilege, there was a grant of authority. Now you're in the mediation and you gathered authority to settle the case, but it didn't occur at a properly noticed board meeting. Did we do anything wrong? Great question. Personally, I don't think so. But even if you did, all you have to do is ratify it at the next board meeting. A mediation is a little wonky in terms of how some of the things that may happen are outside the normal parameters of, everything should be occurring at the properly noticed board meeting. And I agree, it should. All decisions should be made at properly noticed board meetings. But then you get into these weird situations that the statute doesn't necessarily take into account, which includes settlement authority at these mediations. And it's so important to try to reach resolution rather than waste tens of thousands of dollars. And that's what we're talking about. Because if you don't get it resolved at mediation, you are looking at tens of thousands of dollars in litigation. And I've seen the simplest of litigation cases exceed $50,000 easily. So you just have to know that going into this. So you got to put every effort in. And if you find out and one of your members gives you a hard time because a decision was made outside the properly noticed board meeting, you ratify it and close them down. The end. Nice and simple. All right,
And
what
I,
else we got in there for questions, everybody? Or Alan,
I,
comments?
I think that it's important to mention what preparation should be done for mediation because the attorney should also be preparing alongside the association. I mean, the association needs to decide what they're going to offer, but I think they should be getting guidance as to what is our best and worst alternative to
Hmm.
settling at this mediation conference. What are we really looking at if we don't settle? Is this going to be expensive litigation? What are our risks? Do we think that we've got a solid case and we really don't have much risk? Or are we sitting here with, five different potential affirmative defenses that we're going to have to contend with, and we're going to end up in trial spending 50 to 100,000 instead of the usual maybe 10. So those are all factors that really, I mentioned the board should be meeting with counsel in a closed legal meeting to discuss what's going to happen at the mediation conference. They need to understand what the process is going to be in advance of the mediation so that they're not sitting there kind of dumbfounded by what's going on during the conference. They can pay attention to what's being said instead of, well, where am I at? Where am I supposed to be? What am I supposed to be doing? Figuring out who's going to attend is important. Voting, as Jeff mentioned, to ensure everyone has that settlement authority. Figuring out what you're willing to do, what you're not willing to do, and frankly, sometimes what you're not willing to do in a lot of these cases is more important than what you're willing to accommodate. And then just building, the attorney should be helping the board in building a reasonable expectation for what the possible outcome might be. Now, the board's going to know this owner probably better than the attorney, but at the same time, if let's say we've gotten 3 letters saying, I am absolutely not repaving my driveway. Okay, well, we kind of know what to expect. We know this is perfunctory. We're just going through the motions so we can get our litigation in place. Maybe we don't fight quite as hard, although we certainly want to get this resolved. But, if it's a covenant violation, you should be saying without the owner agreeing to cure the violation within X amount of time, we really shouldn't have a settlement here. And again, best and worst possible outcomes, I think you really need to make sure you're communicating among the board. Here's what we really expect to happen if we don't settle. Here's what we really expect to happen at mediation. The other thing you might consider is, do we have any evidence, any documentation that we might want to bring to the conference or have prepared as we've mentioned via Zoom to just put it up on the screen? One of the things I love doing is, putting up on the screen, here's what the property looks like. Here's the neighboring properties. Do you see the difference? And I don't even have to say what the violation is sometimes. The mediator will say, well, okay, I don't like to do this during mediation, but here's what I'm seeing that might be a little different. And it's like, yeah, that's what we're here about. Move on. Um,
So,
but keep in
Ellen,
mind,
you're talking about the mediator and how important, it is to pick a mediator. Because it seems like there's a lot of different styles, let's say.
there are.
Who helps? What's the due diligence a board should do before they pick a mediator? Is the lawyer involved in that?
The lawyer, frankly, from my perspective, should be using mediators that they know to be competent. We get to list when the association is the one sending out this demand letter, as Jeff mentioned, we get to pick 5 mediators that we think will do a good job with this particular dispute. So yeah, I mean, I don't have a problem with the board doing their due diligence, but frankly, in 99% of cases, the attorney's got a list of 5 people that'll do a good job in every covenant enforcement case, and that's the list we include. If the board wants to do further due diligence, you've got the list. We can draft the letter before we send it out. You take a look, you research these mediators and do what you got to do. But
I think Lisa was
presumably
asking.
you're trusting your attorney to know what is right for this particular dispute.
Well, true. And we always pre-prepare the letters. We always put the 5 mediators' names in for the association. It's rare that it happens any other way. But I think Lisa's question was, you've received the letter, the association received it. Now we got to pick one of the 5,
Right.
right? And that's where I think she's asking what
How do we,
counsel's
yeah,
role is.
yeah.
And there, the association would be extremely, how do I say this delicately, unwise to not let the attorney tell them which mediator is the best one suited for this particular task.
Yeah.
It shouldn't be based on the money. Oh, this one's $5 cheaper. No, that's the wrong reason.
That's why I asked the question.
Yes, ma'am.
No, and I also frequently see someone that is, you look on their firm website and they've got ADR, which is alternative dispute resolution, which includes mediation and arbitration, and family law, and nothing else. And they're dealing with an HOA dispute.
Right. No, not who I
Maybe
want.
that's not the right guy to pick.
So one of the questions that came through too, this HOA board had an open special meeting that was advertised to the community to discuss solely the pre-suit mediation. Is that allowed?
Is it
It's
allowed?
allowed. It's not something I'd advise to do.
Right.
They should probably talk to their attorney. You can talk about the general parameters of the dispute, but you've got to stay away from attorney-client privileged information. You have to stay away from the weak points in your case. There's so many things you should not talk about to the community. It's a balancing act because, of course, you're spending your neighbor's money. They want to know what's going on. They have every right to know what's going on to a point, to a degree, because so much of what we would like to share is protected information. So really, they should have the attorney there to explain to the community the general parameters of the dispute. And the attorney is well adept at protecting the attorney-client privilege nature of the communication. And that's why so many times they ask us to appear at those meetings to give that brief
Yeah,
overview.
homeowners want all the details and they get very
Yeah.
frustrated when they can't know
Right.
the details.
Yeah, you want the details, run for the board.
Well, one of them actually
Yes.
asked, is the filing for mediation an official record of the association? And can an owner find out about the mediation and the parties?
Well, that's the beautiful thing, right? The letter is certainly part of the official records. It is not a privileged letter by any sense of the imagination. So they get the letter. But remember, what happens at the mediation is what? Privileged. So
Mhm.
everything except for now, if you have a written agreement that comes out of the mediation, that written agreement is not privileged. But everything that occurred in the mediation is. So the only thing the board can say to, hey, what happened at the mediation? To what Alan said before is, it settled. It didn't settle. That's it. Nothing else, people. Nothing else. It settled or it didn't settle. That's it. It's all you can say about what happened at the mediation.
Wow.
So what happens, and this was a good question, what happens if the mediation agreement is not adhered to by the offending party?
Well, Alan, that's an easy one.
Yeah, you enforce it. That's
You go into
that's
circuit
why
court
we
and you
make
enforce
sure
it.
that agreement actually contains some concrete consequences for failing to adhere to the agreement. Usually if it's a covenant enforcement matter and it's pre-suit, I'll just put in there, listen, if the owner violates this agreement, they have acknowledged the violation. We don't have to dispute whether a violation occurred. We get our injunction. They can't really raise any affirmative defenses other than compliance with this agreement. We don't have to go back to the declaration and prove that we have rights, etc. So you put in a provision in the event of a breach, we have a very clear path to an injunction. Or we have a very clear path if it's one of those innocuous things that, it's fairly straightforward. They need to weed the driveway. We have a straightforward path and they violate, we're allowed to go and de-weed their driveway. And if they interfere with our self-help efforts, then we go to court and they're sanctioned even further. So it's basically a matter of making sure that that agreement actually contains what the consequences you want to be. And if
They
it
don't.
doesn't, then you're going basically starting from scratch, unfortunately, which is why I see so many agreements, especially those that are made directly between the board and the owners that don't really have any consequences. It's an email that says you can have another 3 weeks to do what you need to do. My perspective, get a written agreement form that your attorney can prepare that contains those consequences for the particular type of circumstance that you're dealing with. So if it's collection, this is outside of mediation, as Jeff mentioned, but you're going to have okay, well, this is the amount due as of the date of this agreement. The owner acknowledges this amount is due. The owner agrees to pay in this manner. If the owner doesn't pay, here's what happens. But it's not just well, we know you owe the money, you can pay in 6 months. Because at that point, if the owner chooses not to pay, you're still going through all of the pre-suit crap that takes 120 days or so or more. I would much rather have the owner, at a minimum, agree that you don't have to do anything further pre-suit other than maybe send a default notice under the agreement, and then you can file your lawsuit and move forward with your life.
There's
Because otherwise, you're just handing them more time that they're not doing anything in exchange for. If there's no concrete consequence for these types of agreements, you're just handing the owner something that everyone should be getting. You're basically accommodating them in a way that you're not accommodating everyone
someone
else,
else.
even if you agree to accommodate everyone else. And there's no consequence for them if they don't do what they promised to do. That means it's a meaningless promise.
There's a
A lot
couple
of
other
words to
questions.
say. Put some consequences in the agreement, and you won't have to worry about what happens in the event of a breach.
That's a good point. There's a couple of questions as what type of mediation would you use with an owner who has an emotional support animal that barks whenever it is left alone and is bothering several neighbors?
You know how many people don't know that when it comes to the emotional support animal, that the animal cannot be a nuisance. So you can actually make demand on behalf of the association to the owner of the animal that, yeah, you're entitled to your emotional support animal, but not this one. This one is a nuisance. You need to replace him.
Yeah, I didn't know that. I think that's a great point. Should the association documents contain language on mediation?
It's
To
in the
what?
statute. I don't think it's
What do you think,
necessary.
Al? I don't think it's necessary because it's all in the statute for sure. Um, there could be language, I suppose, that would grant power. In the bylaws, a provision granting certain powers to maybe the president who attends the mediation. You can get creative as a drafter of documents. I've never been asked as yet when we're drafting association documents, the declaration, articles, bylaws, to include any type of mandatory, if you will, um, mediation language because it's so well laid out in the statute and it's a matter of process. So just like, to go to court, it's all in the legislation itself. So,
Jeff, I know you covered this a little bit earlier in the seminar, but there was one question on mediators that they actually mutually agreed upon a mediator who was not available for many months. And the other party proposed a different individual who was not on the original list because the
well,
person they
sure,
chose was
but
not
your fact pattern, I'm going to assume the letter was sent correctly. The pre-suit mediation letter was sent correctly. They picked one. Now that mediator can't make it for whatever reason, and now they want to try to resolve it with a different mediator. I have no
not the
problem
other
with
four
that.
on
The
the list.
parties can agree to that. Nobody's waiving anything under that particular circumstance. It's where the problem lies, where in the response, so the association sent the mediation demand, And in the response, they say, no, we don't agree to any of your five. And we pick this one instead, a different one. How about using this one? Now, they have statutorily failed to properly comply, but your fact pattern was different. Everything happened correctly. Then you go to schedule the mediation and you find out the mediator has no availability for 180 days. Well, we're supposed to do it within 90. So therefore, the parties could work together to select a different mediator. The parties could work together to agree in writing to go beyond the 90 days as well.
And my response would also be, okay, pick one of the other four.
Oh, there you go. I like that too.
Yeah, I like that too.
Nice and
I mean,
simple.
we gave you five. You like this
Yeah.
one. That's great, but you've got four more that are still statutorily compliant. Or as Jeff mentioned, I don't mind waiting 6 months to mediate. I will very rarely say that unless this is a completely separate dispute and it's not just covenant enforcement. I'm not giving anyone 6 months
Well, it's
before we
funny,
file a
Alan,
lawsuit.
when I'm representing the association, I want to get that mediation scheduled as quickly as possible. When I am representing the association and we're the respondent to an owner's mediation request, delay, 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 as a matter of strategy sometimes. Sometimes you want to go faster, but sometimes time is your friend as the respondent to these things. So it's really a matter of strategy for scheduling as well.
So one of the other questions, and this is interesting, how often does a condo association win the disputes?
I mean, I can't give a
Win
specific.
mediation, my God, both parties, you end up, I'm sorry, Alan, I cut you off. I'm so
Oh,
sorry.
it's okay.
The you want to go home at the end of the day feeling a little like distraught. I'm happy that we won, but I wish, well, maybe this had been a little different. That little bit of buyer's remorse at the end of the day on both sides tells me we had a very successful day in mediation.
I like it.
That's sort of the way. What was the original question? I want to go back to Alan on that.
How often does condo association win the disputes?
There you go. So what does winning mean? Right?
Right.
Win the dispute. We don't win. Winning is successful
Agreement.
mediation.
Yeah.
Winning
Right. The
isn't
thing,
like going into a courtroom and getting a judgment for $100,000. Winning in mediation is we're going to settle the case with terms that both parties aren't happy about but can live with. That's what we prepare the client for. You're not going to get everything you want. The question is, can you live with it and keep your money in your pocket so you're not feeding the lawyers for the next 2 years?
So a question from Brenda. I'm not on the board. I'm sorry, I'm on the board and we are in mitigation initiated by an owner. These laws favor the owner, not the board. And unfortunately, again, this is the third time the same owner that's costing all the members thousands. Plus, we, the board, are not found in violation. How do you stop someone from doing this over and over again? Is there any way to stop an owner from doing the same thing over and over again?
yeah, I mean, the only way you would really be able to stop it is if you actually reached litigation and won, and you got an award, and the judge eventually finds this person as a vexatious litigant. There's one other suggestion that I'll make, which is amend your governing documents so that attorneys' fees and costs that are wasted in matters like this can be not only sought from the owner, but levied as an assessment against the owner and the lot or the unit. There's some risk there, but the reality is sometimes having that type of amendment take place and having an owner know that they can be foreclosed if they keep pulling this crap might
Yeah,
lead them to
but is it
stop.
enforceable? I always ask myself that question. I've
Is
had
it
clients
enforceable?
ask, they want to put if we have to send you a violation letter, then you, the owner, have to pay the attorney for sending the violation letter. Good luck trying to get the owner to pay the attorney for that violation letter. There's a cost of doing business as a community association. It might be not profit, non for profit, but it's still a business at the end of the day. And there are charges associated with running any business that are not necessarily directly compensable from the customer. So in this case, the bottle of milk you're buying from the local 7-Eleven has to take into account all the other business operation expenses. The attorney is, to some large extent, a business operational expense. Not always, the fees are not always capturable from the offending owner. And if I'm the judge and I'm sitting listening to a case and you're trying to take someone's home because they didn't pay the $350 for the demand letter sent by the lawyer, you're going to get slammed on something like that. There's no way the judge is going to let you foreclose the house on that. At the end of the day, they're going to try to move heaven and earth against you for that. So you have to take a real world practical understanding of what's going to happen in the courtroom as well. And I'm not saying you might not eventually win in that case, but I don't think you're going to be made whole. I don't, just my 2 cents.
So
So
go
I
ahead.
got one. It's more of a statement instead of a question, but I think a lot of people, can relate. Currently, our board is experiencing litigation. We have had one mediation. The owner doesn't appear satisfied. He has resent his demands. Our lawyer does not think a second mediation will satisfy this unreasonable demands. They are not requests. So I think, when you're in mediation and you're trying to make an agreement between the two, it is still a request, but it's a demand that he's looking for.
It's always a demand. When you're at mediation, someone's always looking to get the other party to do something. I'm not
Right.
sure what the question is there, but
Exactly. I think it's just, if you go back to mediation, it's still going to be demands. I mean, it doesn't look like he's, wanting to give a little bit. So he's
right.
probably right.
And
Well,
there are
that's
many different kinds of mediation too, I want to point out. For example, you could be in the
Yeah.
court and in litigation, and the court could order you to go mediate
Hmm.
to be before the trial begins. So you're not going to deal with the pre-suit mediation process. You're still going to deal with everything Alan spoke about what happens at mediation. But in terms of the setup process, well, the judge just told you, and the judge just appointed a mediator, and you're going to go mediate and see if you can't get this thing resolved. Then there's mediation with the division. This is a strange one. Division of arbitration, mandatory non-binding arbitration, either by agreement of the parties or at the order of the arbitrator. He can order you out of arbitration into mediation and then not let you back into the arbitration, forcing both parties' hands into litigation.
Even after you've already been to mediation once.
Yep.
yeah. And
If
it's
you,
the same
that's
with
yeah.
the pre-trial. It doesn't matter that you mediated before the lawsuit was filed. The court's going to order you to mediation, but you can request because you've already been to mediation that the court dispense with it, meaning you don't have to go. And you'd really have to show the judge at that point that nothing has come up in the case that would cause there to be new evidence and new perspectives that would make another mediation worthwhile.
Except that, to Alan's point, I'm aware of a very recent case where the court ordered the parties to mediate 4 times. 4 times, maybe it was 5, completely unresolvable. Lo and behold, at the last mediation, a week before the trial, guess what? They settled.
Wow.
But you just never know. And it
So
was cheaper, probably. Those 5 mediations were cheaper than a week of trial, that's for sure.
and one of the other questions that we had is typically what does a mediator cost?
$1,800 an hour in my dreams, right? $400 an hour to about $500 an hour is
Yeah,
average
you've
rate.
got some that are insanely experienced and charge insane rates. I know of some in Florida that are extremely experienced, although not necessarily that much more than Jeff, that charge 650 an hour or 700 an hour. We think 400 to 500, as Jeff mentioned, is probably a reasonable rate for people with the level of expertise that you've got in the room.
Yeah, multi-party, right? If you're dealing with 15 parties, because you have these big construction defect lawsuits and you got everybody in the world in there, those mediators deserve to be paid that higher sum. But for what this type of mediation is, I think 400 or 500 an hour, which is split between both parties, is very reasonable. But think about it, the day of mediation. So you've got the pre-suit mediation demand, counseling the client before the mediation, attendance at the mediation, plus each side splits the mediator's fees. You're looking at, I don't know, 2 to 4 thousand for that pre-suit mediation half day before it's all said and done. I don't
And
know if you see it differently, Alan, or
that's what I
not,
think
but
the question was.
No, I'm in the same boat. I mean, a
And
lot of mediators just understand also will have their minimum fee, so personally, if I'm going to take the time out of my day doing the community association work that I need to do and serving our firm's clientele, I need to make sure that there's at least enough time in that mediation to make it worth taking the time away from my general day to day. So my
2 hour minimum
minimum
each
is
side,
3 hours.
Al?
I'm sorry?
2 hour minimum each party? Yeah.
Oh, per
Yeah.
party? No, I do 3 overall, so you're doing 1
Oh,
hour overall.
and that's interesting. Okay. Yeah, because I am 2 hours, 2 hour minimum per party. So a
Okay.
minimum, so it's like a half day minimum, because it's going to be a half a day no matter what. So,
Right.
Yeah, and it's very rare that these go 2 hours. The ones that are 2 hours are the ones where both parties are doing it purely for the purpose of saying they did it and complied with the statute.
Mhm.
Even then, I try and keep them in the room and say, listen, you're already paying for my time. You might as well try and take advantage of it and see if you can reach some kind of semblance of an agreement on some of the issues. And I personally, I'd rather see a full settlement, but my perspective as a mediator is if I can see that the parties are understanding each other better, that they have come closer to a resolution, I've done my job. I can't control whether they settle or not. I can only control whether I bring them closer together.
And you can tell when they're just going through the motions, I'm sure.
Oh yeah.
pun intended, going through the motions.
Yeah.
Well, I really appreciate all the information that I thought it was a very good seminar, the information that you gave out to everyone today. We will be coming out with association matters for 2026. We'll make the announcement for those at the beginning of the year, but we appreciate all of you attending. And Jeff and Alan, we truly do enjoy all of these and the information that you provide us. So thank you so much.
Don't
Thanks
forget
for
your
having us.
survey. Apparently, Jeff Solomon just sent in a little reminder to everybody for follow-up surveys.
In the
So,
chat. Make sure you take the survey. Let everybody know how it was. I hope you all have wonderful holidays with the upcoming season. It seems like it's going to be here tomorrow.
right?
Thanks again, everyone, for attending today. We truly
Thanks
appreciate
for
it.
having us.
Thanks, everybody.
Thank you.
All right. Have a great day, everybody.